assumptions, there will be, we will have an agreement, we agreed on between us that we will actually submit to the European Union by 2022, like in 2 years' time, when the current regulation ceases to be enforced. We'll submit an agreement between the two of us that will give access to this kind of fisheries, fish stocks, between 6 and 12 nautical miles of Greece in that particular area, to give to Italian fishers. So this is a concession on the part of Greece, to put it very bluntly. However, this was, you know, it was just a teaser to convince Italy to sign this agreement. Okay, but this is, it remains to be seen because I haven't seen the documents yet. But I'm sure what this is all about. Okay. Now, if Nicholas could move to the other map between Greece and Egypt. Great, thanks. I also have to tell you that I was, because I was working for the government, in the Greek government between I was not so old, between 2016 until 2019, I negotiated both the Italian agreement and this agreement that you're going to see, but I was not in the last phase of the negotiation, so I cannot give you any informed details, even if I could, right, on what was actually the background of the negotiation in this respect. Now, this is you see the line here between A and E. It is a delimitation agreement signed in August 2020. Again, Greece has ratified this agreement. I think the Egyptian Parliament has not yet, but it will be soon. Both agreements will enter into force, I'm sure about very soon. This agreement is a partial delimitation agreement. So both Greece and Egypt decided to have this, you know, between the 26th and the 28th meridian, as you can see, and leave other areas, for example, areas like here, you can see after westward of E or eastward of A, to be delimited in the future. This was negotiated from the scratch, I have to tell you. It's not because some people, and this is, we can discuss later on, was this, they said that this is a, you know, it was like a response to this Turkish-Libya agreement. We may refer later on this. It was this partial delimitation agreement, I have to tell you, was discussed from one of the, you know, not from the initial phase of our negotiation with Egypt, but from 2017. This was the discussion we had to have a partial delimitation. We have not, when I was in the delegation, we didn't agreed upon limits, but however we agreed it will be a partial delimitation. Now the agreement is for an EZ, so it's an EZ delimitation agreement. And very interestingly, this is something which I think the Greek public has not figured out. So Greece, in the Article 2 of the ratify law of this agreement in the Parliament, Article 2 actually proclaims an exclusive economic zone in this area in Greece. It's the first time that Greece, it's not a huge coast, but has many islands and it's a maritime nation and a lot of coastal length if you take into consideration the islands. It's the first time that Greece actually proclaims a maritime zone. We don't have any, we don't have Kodiki zone, we don't have an exclusive economic zone, we have not delimited or delineated the outer boundaries of our continental shelf. So it was something which for us, you know, Greeks was a monumental, you know, a moment that we always remember. So Article 2 of the ratifying law says that we are proclaiming However, in terms of official proclamation under Article 75 of UNCLOS, we still need to deposit the charts, the relevant charts, to the United Nations Secretary General and Special Division for Ocean Affairs and the Law of the Sea to have an official proclamation of an EEZ. Now, in terms of the limitation, the boundary, here you can see that this is a line shifted, you know, eastward, northeastward. As it has been said, Greece takes 45% of this area, whilst Egypt takes 55%. So Greece loses in that sense, but loses only like 5%. So it's not on a median line as such, it's an adjusted median line. Now, in Greece, and we had another meeting, it was like on Thursday of the International Law Association, Greek Hellenic branch had a meeting, and there were other commentators saying that we acknowledge a reduced effect to our islands. So the islands of Crete, you can see here, Kassos, Karpathos, and half of Rhodes. I think this is a misstatement. In what sense exactly? In the sense that there's no justification in the agreement or by the two parties why they had this concession line. Was because there was a disparity, a disproportionality of the length of the coast, the relevant coast you can see here, or because the islands are, you know, away from the coast of Greece, or and so on and so forth. So there's no official justification. So I will be it's a word of caution to other commentators not to jump into conclusions what Greece did consider or not consider. At the end of the day, in terms of the limitation, and I have to say to you, I'm pretty sure that if we went to the ICJ with Egypt, we might not have taken this agreement in the sense of the area we earned. I may have some, you know, some difficulties or some concerns on the drafting of the agreement, but I won't, you know, it is another issue in this regard. However, this, I think it's in terms of the delimitation as an excellent agreement, of course, a partial delimitation agreement, and Greece would like to have a full delimitation agreement. However, there is another state in the region, right? The other two states in the region, to be perfectly well, and I think it's a very good, you know, assist, as we say in basketball, in a kind of basketball like Serbia, to my other two friends and colleagues to say what is actually happening here. Okay, and I may stop now. Sorry if I took more time as you were.
I agree, Akis.
And thank you for this.
Yes, Akis, thank you for this introduction. And maybe I will just intercede for a second, because you mentioned this Greece-Egypt agreement, and I read somewhere that after the conclusion of this agreement, the Turkish foreign minister stated that actually the agreement supported the thesis of the Turkish state that the islands do not have a continental shelf. It's kind of strong statement. So, yes. So I would like maybe to now pass on the floor to Emre, and he can connect maybe with this thesis of the Turkish foreign minister, and also what you've said, and to offer us his own introduction to the topic. Please, Emre.
Thank you, Mihajlo, for having me today and inviting. So I'll be happy to reflect my opinions, and I'm going to start with a map. First, I will answer your question about what Foreign Minister Çavuşoğlu said and what Turkey believes about the Greece and Egypt maritime agreement. My personal opinions differs from what Turkish government would say. So I want to make it clear at the beginning. I strongly believe that the Greece and Egypt agreement, maritime agreement, is in line with established rules and principles of international law, maritime delimitation law, which gives a little bit reduced effect to islands, but almost full effect to this big Greek islands, to Crete, which is a massive land. But from Turkish perspective, Turkey believes that agreement is not enforceable and cannot be enforced against Turkey, and it's contradicting with Turkish EEZ rights in the region. So Turkey rejects the agreement, basically. And as you know, Turkey recently signed a maritime agreement with Libya. So once we put those two maps together, which Nicholas map was showing, they're overlapping with each other. So there's an area both Turkey claims and Greece claims, also Libya claims. So when there is an overlapping maritime area, where we talk about delimitation. If there is no overlap, we talk about entitlement. So those are two different concepts. Entitlement is straightforward. Even a small island in the middle of ocean can have up to 200 nautical miles of maritime zone, EEZ, maybe like even more than that, continental shelf up to 350 nautical miles. So this is called entitlement. If there is no other challenging land, for example, an island, Clipperton Island, it's a French island in Pacific Ocean. It's a little bit bigger than a soccer field, but it's an island technically under Article 121, and it generates a maritime area more than landmass of Nicaragua, Honduras, El Salvador, Belize combined together. So the closest countries to it. So a small island can generate this big land. So when there is an overlapping area, we talk about delimitation. We don't talk about entitlement anymore. Delimitation means what effect that island should get. So we can make a basic comparison. You have a car, you can go up to 200 kilometers per hour, okay? It doesn't necessarily mean that you can go 200 nautical miles everywhere. In this city, you can go up to 80 nautical miles kilometers, or in a parking lot, maybe 10 kilometers. So there are, the second question is about delimitation. And we know that islands have different effects, in maritime boundary delimitation based on the specific geography. So we have islands in state practice or court decisions which have full effect. Corfu, a good example, Akis Cape. So, and another island, Corsica, French island, or Shetland, Mallorca. These are big islands, Sicilia. So the big islands generally have either full effect or somewhere close to full effect. But on the other side, in state practice, case law, court decisions, we see many examples of small, isolated, remote islands which have zero effect or very reduced partial effect. So the problem, so now this is just introduction. I'm going into the map I am showing to audience. So the problem on the map we see here, we see a Greek claim, the blue line, and red line, Turkish claim. And the green line is my line, where I worked on it for years and I draw myself. So the problem with Greek and Turkish claims, they both have wholesale approach. Wholesale approach means either islands have full effect, even Castellarizo, from Greek perspective, or from Turkish perspective, islands have no effect, including Cyprus and Crete. So those have, both of them have problems, serious problems. And this is understandable, by the way. Like we shouldn't judge Turkey or Greece having this, maps, claims being, shared on the publicly. Having said that, Greek never said it's our official position, so we gotta add that to. So here, all islands are giving either zero effect or full effect. No, this is not the case. So when we look at the case law, just a couple of examples. I'm just gonna share very briefly. So, so these are some maps we can see here. Corsica, it's a big French island, very comparable to Crete. I think it has around 1 million population. So as you see, even if it is very close to Italian boundary, Italian land, it wasn't fully enclaved. It has given, what I see from here, almost full effect, if not full, okay? Another example here, this is Norwegian maritime boundaries. So we see Shetland Islands here, belongs to United Kingdom. So what I see here, it received almost full effect, if not full. So these are big islands, and we can give more examples. Just to make it short, I brought only two here. So we know Crete has I think over 600,000 population, I guess, and land-wise, if it's an independent state, it's like probably bigger than many, like tens of other island states, which is 5 times smaller than Libya. Libya's population is like 4 or 5 million. So population sometimes matter, even if it doesn't matter on the paper. But we know court decisions do give consideration to population. So that's one thing, Crete and Castellarizo. So Crete, we know that in state practice should receive almost full effect. So we shouldn't discuss that. And I'm going to give another example. So this is a map, delimitation map, between United Kingdom and France. And here, these islands, very similar to Greek islands, located on the wrong side of the boundary. Wrong side means on the other side of the hypothetical equidistance line, provisional equidistance line. So islands on the closer to opposing state generally have reduced effect. It's just practice, not necessarily. It may have full effect, depends on the specific particulars of the case. Here, these UK islands were giving semi-enclave in the northern side. Southern part, court was not asked to delimit, so it didn't go in there, but we see an enclave here. So when we applied this hypothetical situation to Castellarizo, sorry, Mace is in Turkish, I said Mace in here. So Mace would have, Castellarizo would have a similar enclave of territorial sea. And another example here is 2 French islands, Saint-Pierre and Miquelon. Population and territory-wise, it's almost as big as Karpathos, a Greek island, which is a relatively big island. So here, these 2 islands were giving reduced effect, So I'm not going to go in details, but we can see on the map, it's giving reduced effect and a corridor to access to high seas. So if we apply this hypothetical situation to Eastern Mediterranean Sea, we would have this type of map. And I argue against this corridor because there's no high seas here, and there's no need to give access to Castellarizo to access high seas. And it would also block Turkish water because it should extend more than 200 nautical miles, which wouldn't work in a semi-enclosed sea. So these are two examples. So we can give 10 more examples about how islands are giving reduced effect. Nicaragua, Colombia case, Bangladesh, Myanmar case, St. Martin's Island. So, and also one last thing, maybe which is not talked before much, but we know that another factor in maritime boundary delimitation is when three coastal states are next to each other, and the coastal shape of the geography is concave. There's a concavity, and one state in the middle is squeezed by two other states. This was a case in Slovenia decision too. Italy on one side, Slovenia in the middle, and Croatia. So in this type of situation, there's an established case law where the country in the middle is being squeezed by a triangle if you apply equidistance line. So court says you need to allow some sort of opening for the middle country, and this was the final boundary. So even though it is not exactly the same geography, but once we consider this Greek islands forms a coastal mainland, and Cyprus on this side, let's say it is a continuous mainland here, Cyprus, and Turkey's situation is similar to what is in North Sea case. And also considering that these are not full mainland islands, so Turkey should be treated favorably. So this is another fact. And based on these considerations, this is the map I draw myself. I'm just gonna end my conversation here after explaining this map. So here, what I'm saying is Castellarizo has no excuse to have any EEZ, just because it is it has an excessive distorting effect on Turkish southern projection. So here, Turkey's southern projection, where the green line involves. And this island has a very distorting effect, and I don't think court will respect this. And second, Crete is a massive land, and it doesn't necessarily directly challenge Turkey's coastal opening. So Crete should have almost full effect. Why I'm saying almost full effect? Because normally I would say full effect, but because of the shape of the coastline, Turkey is being squeezed in between two. Like this map, what Greece claims, equidistance line, you see it makes a triangle. Let's say there's no Castellarizo, still it's a triangle. Turkey is being squeezed. So we need to consider that. So what I'm saying here, Rhodes and Karpathos, Kassos should have two-third effect. Two-third effect is in line with previous case law. Nicaragua, Colombia case was a good example where islands received one-third effect. Here, islands are bigger. By the way, in Nicaragua, Colombia case, the biggest island, San Andres, had almost the same population as Rhodes. So here, what I gave is two-third effect to Rhodes, Kassos, Karpathos, and full effect to Crete. But at some point here, the line was supposed to go like this. Can you see on the map? I don't know if you can see my mouse here.
Yes.
So I just gave a little bit adjusted effect here, just to make sure Turkey's southern projection here, right here, the green line is respected. So when we look at the court decisions, what we see at the end is court would like to respect what is given by the nature to the neighboring country. So when we look at the map, what I see here, Turkey has a clear southern opening, has a huge landmass, defining the northern boundary of Eastern Mediterranean Sea. This is a fact, a geography. We cannot just fully refashion the geography. We should respect this, and we should not block Turkey's southern opening. At the same time, the Rhodes and western part of Rhodes, this area, it's like by geography given to Greece. You know, Greek islands dominate this area. We see huge islands. These are not small islets or rock formations. These are islands, they have population. So this area geographically, to me, more belong to Greece, just looking from a non-expert perspective. And Egypt has also a clear northern projection. So at the end of the day, court will make a decision respecting this geographical fact. And my map respects this geographical fact. The weakest part in my map is how much Cyprus should receive effect, because Cyprus is a sovereign independent state. So Turkish audience will say, hey, there are two states. Yeah, like there could be two or one, doesn't matter. So it's as a geographical feature, Cyprus is a big island and it's an independent state, whether it is Turkish Cyprus or Greek Cyprus or both or one united Cyprus. So that's a different discussion. So this is the weakest point of my map, maybe, because a court may say, no, like this is an independent state, I am going to give full effect to Cyprus. Why I give partial effect? So in the northern side, northern part, where Cyprus and Turkish mainland, here, right here, if you can see with my map, this area, here, the coastlines are opposite. In opposite coastlines, generally, equidistance line or median line, more properly, is equitable. Generally, this is the state practice. And this is only 38 miles distance in between two states. And Turkey receiving 19 and Cyprus receiving 19 miles each, and median line sounds equitable to me. Or court may say Turkey has longer, coastline, as in Malta case. So I'm going to adjust a little bit in favor of Turkey. This could be an option too. So I'm not going to argue on the northern side, but on the west of the island, right here, the situation is different. Here, coastlines are adjacent. What does it mean, adjacent coastline? It's a technical term where two countries are not facing each other, they're facing the same direction, which is here. Now, it's adjacent coast, technical wording. In adjacent coast, median line or equidistance line, equidistance would be more proper in this case, generally leads to inequitable solutions. This is in court decisions. We can give many examples. And I explain about the concavity as well. Plus, these two states have only 38 miles distance, and Turkey has longer coastline. So everything in equidistance line goes against, in favor of Cyprus and against Turkey. Location, geographical formation, coastline shape, everything. So it's not same as Egypt and Cyprus. Egypt and Cyprus can make a median line. That's not a issue for Egypt or Cyprus because it's median line. So there is not much problem in applying. So Egypt can still claim no, like in Malta-Libya case, Malta had shorter coastal length, proportionality, principle of proportionality, so they can claim more. So, but in here, it's very tricky point. That's why I gave Cyprus 2/3 effect. It may sound weird because why you are giving 2/3 to Cyprus, but almost giving full effect to Crete. Location, distorting effect, and distance from Turkish mainland. It's kind of, it's closer to Greece than Turkey. So this type of consideration, at the end of the day, that's what I believe would be equitable. Court may say, no, I'm giving more 3/3 effect to Cyprus or full effect. But this is what I believe a fair resolution would be in Eastern Mediterranean Sea.
Thank you, Emre, for this introduction. But as far as I see the dispute, it seems to me that any bilateral negotiations between Greece and Turkey, which would eventually try to solve dispute, cannot disregard Cyprus because simply the interests of Cyprus would have to be taken into account. And with this, I would like to move on to our third speaker and his introduction because he is the expert from Cyprus. So Nicholas, please, now the floor is yours to present the arguments of your side and your general view as an international lawyer on the dispute, please.
Good evening, everyone. Thank you, Mihajlo, for the invitation. It's a great pleasure to be among distinguished colleagues this evening. It's also a great opportunity to exchange views and discuss the current situation in the Eastern Mediterranean Sea. By way of a general introduction, I'd like to point out that the Eastern Mediterranean Sea has a long-standing naval tradition. Of course, the activities, the maritime activities revolved mainly around fishing and seaborne trading. However, on the verge of the 21st century, the discovery of offshore hydrocarbon reserves changed the perception of the states as regards oil and gas. States decided to collaborate under the aegis of international law. That's why they came up, they concluded a range of international bilateral agreements, international maritime boundary delimitation, search and rescue, agreements on the joint development of hydrocarbons, some of the examples. I'd like to start by showing a map illustrating the delimitation agreements in the region. Here you can see the Egypt-Cyprus agreement signed in 2003, the Lebanon-Cyprus agreement in 2007. It has not entered into force, and the 2010 Israel-Cyprus agreement. All three agreements are based on the median line. So there's, it seems that 4 out of 7, 5, if we take into account Greece, states in the region agree, support, are in favor of the median line method principle. Of course, you can see the dotted lines. This is a claim made by the Republic of Cyprus based on the median line. There is no delimitation in those areas, so it's only a claim. But we can only talk about the delimitation agreements only to the south. 3 delimitation agreements, even though Lebanon has not ratified the agreement, it has submitted define the coordinates with the agreed line with Cyprus. So Lebanon has endorsed the delimitation agreement, even though it has not ratified it. Of course, as Emre has mentioned, Turkey has put forward its own claims. It is interesting to note that, let me show you the map. Sorry. So this is the first map that Turkey submitted to the UN. Of course, Turkey, the Turkish ambassador Efthymios, I don't know if I pronounced it correctly, Emre, Ambassador Efthymios has published maps since 2012 demonstrating the Turkish position. But this one is the first map that Turkey has officially transmitted to the United Nations. So you can see the vast maritime area claimed by Turkey, and of course this is of the southeastern and the rights of the Republic of Cyprus. Of course, Emre mentioned that Cyprus should get only 2/3 on the west. Of course, we've already said that Cyprus has received full effect vis-a-vis Egypt, Lebanon, and Israel. We should also bear in mind that the ICJ in the Libya Malta case gave additional maritime space to Malta. It was not a median line, of course, but Libya has 8 or 9 times longer coast than Malta. But again, Malta received a significant maritime space because it is an island state. So the fact that Cyprus is also an island state should be taken into account. Moreover, it is interesting to note that international jurisprudence has avoided the enclavement of islands, taking into account security and defense factors, the security and defense factors. So it's not only geography. Of course, the main factors we should take into account, into consideration when delimiting a maritime area is geography. Nevertheless, there are also non-geographical factors we should take into account. In the Eritrea-Yemen case, the arbitral tribunal avoided the enclavement of islands on the basis of security concerns. So, as I've already mentioned, as I've already argued in a previous, very interesting discussion with Emre, Castellorizo is not an isolated island, so we cannot automatically apply the pre-existing international jurisprudence. It is part of a geographical and administrative complex, namely the Dodecanides. So Castellorizo belongs to a wider complex, a wider island complex with Rhodes and Carpathos. So when it comes to delimitation, Castellorizo should not be treated as an isolated island facing a huge Turkish coastline. So we need to add the sum of the lengths of the coastlines of all the Greek islands projecting into the relevant area, and then compare that sum with the Turkish coastline. So it's a unique case. International jurisprudence has recognized in the Bangladesh, Myanmar, and the Nicaragua, Costa Rica cases that every case involving islands is unique. So we cannot have predetermined rules and apply them without any change in every case. So we need to bear into account, bear in mind several factors, both geographical and non-geographical, in order to delimit this particular maritime area. Of course, I'd like to make a comment on the Greece-Egypt agreement. Greece seems to have slightly shifted its position on the median line, but that does not create a binding precedent. That doesn't mean that Greece cannot still claim median line and full effect of islands in a future delimitation, even though Turkey, in a letter sent to the UN on the 21st of August, said that given that you accepted, referring to Greece, given that you accepted reduced effect to Crete, you cannot claim full effect for Castellorizo or Rhodes. But these are political arguments, not that legal. So in a future delimitation, Greece can still argue that its islands, the islands of the southeastern Aegean, may generate full maritime zones, and the limitation should be affected on the basis of the median line. It is a very turbulent region. We need to be cautious when dealing with these issues. Another point I'd like to make is the rules on undelimited maritime areas. Of course, we know that in order to have a violation of sovereign rights, we need to be certain about the particular maritime area, to which state a given maritime area belongs. However, even in the absence of a maritime delimitation agreement, there still are rules. So according to Article 74.3 and 83.3 of the Law of the Sea Convention, which have not been crystallized in customary international law, but nevertheless reflect customary principles such as good faith, peaceful resolution of peaceful settlement of disputes. Those provisions stipulate that when there is no delimitation, to refrain from unilateral activities that might jeopardize or hamper the future delimitation. And according to the existing case law, we deem that unilateral activities prohibited under those provisions are unilateral drillings. And in my view, even though it's not that clear, it is supported by the Guyana versus Suriname case. Even seismic surveys in undelimited areas might constitute a violation of the obligation. But I'd like to make clear that the violation of those articles, the violation is distinct from a violation of sovereign rights. So we're not talking about violation of sovereign rights. We're talking about a violation of the obligation of states to abstain from unilateral activities in an undelimited maritime area. So we need to examine the activities taking place in the region under the prism of those rules. That's what we need to have in mind. And that's all from me for now.
Okay, I have unmuted myself. Thank you, Nicholas, very much for your introduction. So we have now got a clearer picture of all the stakes in the dispute. And after all this, maybe I would like to start with one question concerning the avenues for dispute settlement among all these three parties. So can you comment about the possible jurisdictions which can be explored if the negotiations continue to fail? So whichever one of you would like to start, but I would like just to see your opinion on that, please. Maybe Akis.
Yeah. Thank you, Mihajlo, and great congratulations to my other colleagues whose excellent presentations. I loved listening to your views. Now on possible avenues, I mean, it is, to me, it is soon Greece and Turkey will enter into exploratory talks, the 61st round. So you imagine it has been going a long time. So this can also give a heads up of how much shall we anticipate for our outcome of this negotiation. It would be very difficult to reach an agreement, a bilateral maritime agreement, or a trilateral maritime agreement with, let's say, including Cyprus in the picture. So my view is that, especially in bilateral level, Greece and Turkey will one possible recourse is the recourse to the International Court of Justice. Turkey is not a part of the law of this convention, so it's difficult to accept, for example, the International Tribunal for the Law of the Sea. Turkey might want to go to arbitration. It depends. If I were consulting the Greek government, I would say go to the ICJ. Okay, not go to the arbitration for many reasons. My take on this is that, from a Greek perspective, it's a win-win situation in that one sense. Firstly, it will be good to have the permanent judicial organ, the permanent organ of the United Nations to adjudicate on that case. And this, I think, will be, it will be difficult for states not to abide by the outcome of the ICJ's judgment, right? But also, I think it will be also beneficial internally. So the audience in Greece, you can see, and I think both Emre and Nicholas saw the map. So also Greece has, a very full-fledged median line claims, right? Which, anybody can predict that this will not be the outcome. I'm not sure whether Emre's will be the last, Emre's picture map will be the final one, but I mean, it might not be the one, right? Might not be the full effect of islands, might be the median line. But if we go to the Greek public and say to them, okay, guys, you always say about the international law, we preach about the international law. Now we went to the international law, the court, right? The court has made this judgment, so you have to abide by this, because otherwise, if the Prime Minister Mitsotakis, whoever signs up an agreement with President Erdogan and gives what Emre said, nothing to Castellorizo, next day we'll lose the elections, right? Or we'll be very close to lose the elections. Okay, so I mean, this is something that's for us, it's really important, I think, to have the seal of the International Court of Justice in this kind of in the outcome. But this is my take.
I see. Emre, what is your opinion?
So I agree with Akis. I mean, what he says definitely is the most ideal path. But before we going there, I think there are steps we need to take. First, we know at the end of the day, if this is a negotiated solution, there has to be a compromise. But to be able to compromise in between, so we have to be on the table first. So what NATO did 2 weeks ago, just try to prevent a military confrontation potential. So once we are talking about military confrontation, we're not talking about the negotiation or sitting on the table. So it's good that we are having the 61st exploratory talks. I think there's a long gap because they started just now, because there was years of gap. We didn't have any exploratory talks. Now it's good that the parties are negotiating. I think once a Greek expert says, yes, Castellorizo should not have full-fledged effect, and a Turkish expert says, yes, Crete and Cyprus cannot be enclaved to territorial sea zone. So we done with most of the dispute. Now we're adjusting the line. So I think that's what we need now. And in terms of the taking the dispute to in front of a court or arbitration, as far as I know, the Turkish foreign policy or reaction would be, once we solve issue, we solve everything. Otherwise, I'm not going to the court. So this is a problem. So there are, from Turkish perspective, there are issues other than maritime boundary delimitation. Cyprus problem, delimitarization of the Greek islands, and the islands which ownership was not given to Greece. So these are Turkish opinion, Turkish official stance. So once we go to the court, let's take all these as a package to the court. And this is, so obviously Greece will say, okay, no, like I'm not disputing any sovereignty on the islands. It's clearly by international treaties, sovereignty are given to Greece, and there's no demilitarization problem. These are sovereign territories. And plus for Cyprus issue, Greek position is clear. Turkey is invading the northern part of the Cyprus. Turkey claims the other way around. So what I'm trying to say is, I don't think Turkey will be ready to go to the court unless we have resolving all the dispute, which will never happen. So that's another problem. And going to court, International Court of Justice will have potential to severe repercussions on Greece and Turkey. For Greek side, the former MP recently on Greek TVs mentioned that we have to tell our public, our folks, that once we go to International Court of Justice, there's a high risk of losing maritime areas, huge maritime areas around Castellorizo. So there's a big risk for Greece. And for Turkey, going to International Court of Justice might mean, if we are resolving the whole dispute, mean Turkey recognizing Republic of Cyprus, and which is a bigger problem than the maritime boundary delimitation issue. So at the end, going to court, to me at this point, is not very soon. The best case scenario is both parties have understanding that, okay, even if we lose votes domestically, we should solve this problem for the sake of prosperity in the region. That's another problem. Maybe politicians are feeding on this, right? Because in Turkey, I can tell you this, Erdogan has a very strong opposition, very strong. Even if he does something good, so he will receive a strong opposition. But when it comes to this maritime boundary delimitation issues, he has 100% support from everybody, like full opposition. You never see opposition unites together on a foreign policy issues. It's the first time after Libya agreement. And what I'm saying is, how come you agreed on one thing, first time in history, which is blatantly against established rules of maritime boundary delimitation law? That means, we're still taking actions with the emotions and militarist and national, sentiments. So we should get rid of those, focus on, okay, what is equitable, what is legal, and try to find moderate people who understand both parties and willing to take initiative for the sake of prosperity in the region, and they take some meaningful action. That's the problem.
I understand. Nicholas, do you agree with the other two co-panelists, or you have some other opinion concerning the possible avenues of dispute settlement? Nicholas.
Well, my view is that the maritime disputes in the Eastern Mediterranean should be resolved by the ICJ. So I agree with Agis, but I don't think that Emre disagrees with that. But he outlined difficulties facing that option. Of course, I'd like to raise another issue. Emre alluded to that, the fact that Turkey does not recognize the Republic of Cyprus. That's a very interesting general international law matter, because Turkey did recognize the Republic of Cyprus back in 1960, but decided not to do that as of 1964 onwards. And as international lawyers do know, a state cannot derecognize another state. So it's a matter of recognition of governments, because the current Turkey argues that the current government of the Republic of Cyprus does not represent the Turkish Cypriots. Even though the practice of recognition of governments had fallen into dispute years ago. I think, and I'm saying that because there's a decision by a high court a couple of months ago, where the court decided, because the Foreign Commonwealth Office, these are very interesting developments in terms of general international law. But I still believe that the ICJ should be the forum where the dispute should be resolved. Another interesting fact is that Cyprus has already invited Turkey to have recourse to resolve their disputes before the ICJ. Turkey rejected that, explicitly rejected that in July 2019. And when Cyprus sent a note to Turkey proposing the conclusion of a compromise of a special agreement for a joint recourse, joint submission to the court, again, there was no answer. So it seems unlikely that Turkey will agree to submission to the ICJ as regards Cyprus. So it seems highly unlikely. There might be a chance to do that, but still, as regards that option.
Thank you, Nicholas. So if I've understood correctly, I think Emre mentioned that Turkey has signed a bilateral agreement with the Northern Republic, Turkish Republic of Northern Cyprus, concerning delimitation. Of course, this agreement is not binding on the states which are not recognizing this entity. But what is happening with its factual application? I'm somehow trying to make a parallel with some delimitation agreements which neighboring states of Serbia have signed with Kosovo, who is also an entity which is not being recognized by Serbia, but still in practice, these delimitation agreements are being implemented in a way by our state authorities on the ground. What is happening as concerning Greece, for example? Did it take into account this agreement as factually valid? If I'm making myself clear, Akis.
Yeah, I mean, I think I beg to differ with you, Mihajlo, in the sense that I think it's it's quite different, the situation with Kosovo and TRNC, the Turkish Republic of Northern Cyprus, because, you know, the TRNC, according to the Security Council's resolution, according to the international law, is a nullity. It's an obligation of non-recognition of the state. So this is in the sense that no state could actually recognize not only the state, but also the product agreements of the state. Kosovo is quite different. I mean, Greece also doesn't recognize Kosovo officially, right? So it is however, in the sense of, in terms of the, ICJ and the Kosovo Advisory Opinion of 2010, there is, the Kosovo people had the right to declare their independence. And this was juxtaposed, with the TRNC under paragraph 81 of this advisory opinion, saying that TRNC this independence is a nullity because of the violation of a use cognizant norms and the prohibition of use of force. But anyways, I mean, I think in this respect, I mean, I think, and I agree with your comments and all of the previous speakers. I think that the problem, if we isolate it, so there was just maybe it's a science fiction what I'm going to say, but there was like another professor, a very good colleague and friend of us, Professor Maria Gavunelli. So she gave a talk once, I think it was Nicola was there, and said that the idealistic, the utopian solution would be maybe to have like either an international conference on the Mediterranean, which was also proposed, I think, by some also experts and some states and in terms of very recently, but also have either an international conference or a conciliation commission that all parties will take place, as happened with East Timor and Australia. In that sense, that it would be great if Turkey could recognize Cyprus and sit at the same table with Cyprus, to have a comprehensive solution between Cyprus, Greece, among Cyprus, Greece, Egypt, in that area, right? And this will be a fantastic opportunity. Okay. However, this seems more utopian rather than realistic and pragmatic in current terms, and therefore that's why I think that Emre said that we have to pursue negotiations, and I agree with him that it would be difficult for Turkey to accept the ICJ jurisdiction in this phase, right? And we have to try to convince both our public and our politicians to take a very a bold step forward. And to me, for example, if I would say, whenever I'm asked in the Greek audience, so if Greece loses Castellorizo, what I will say, we don't have Castellorizo right now, in the sense that we don't have a full-fledged EEZ and continental shelf to explore and exploit. So we won't lose anything in terms of losing. We always, whenever you agree with other states or you go to the court, you win. Now, that said, I think that having the full, as Turkey wants, the full, cards on the table, demilitarization, sovereignty issues, and the list goes on, I think it's a no-go for us. I think it's a non-starter for us. And this probably will be I think that it will be the most difficult part of the negotiation, as far as I'm concerned. Thanks.
Thank you, Akis. One more issue which has come to my mind now, and it's more connected with control over these natural resources in the disputed zones. How much is the dependence of the population in these respective territories upon the prospective use of resources in maritime zones can be influential upon the application of the principle of equity in the eventual delimitation? Emre, can you maybe comment on it? I know that this is one of the factors which is usually taken into account on the application of the principle of equity as a correction of the norm for delimitation.
Exactly. So before I go there, can I give very brief?
Yes, sure. I didn't
ask in the previous question.
Of course, yeah.
Yeah, but because I think it's important. There is a Akis explained, clarified the issue a little bit. So in terms of we have these problems. Like, it's not just northern Cyprus; it's also Libya. Whether GNA, the current Libya Tripoli government, is the legitimate government or not. So Greece does not recognize, I guess, as a legitimate government, even France. So we know that international community is divided into two, whether they are supporting Haftar government or Tripoli, the GNA government. So same for the northern Cyprus, Akis mentioned. So United Nations General Assembly had a resolution on this, that no country can recognize northern Cyprus, whatever. So I need to emphasize this. Even though I believe Libya-Turkey agreement has many problems on maritime boundary delimitation law, plus on making an agreement with a government whose future is not clear. You know, if you are making a maritime boundary delimitation agreement with another party, which has legitimacy problems, where we know there's a civil war, international community divided. So that means if that government loses the power, then the maritime delimitation might be repealed afterwards. So international law wouldn't like this. So maritime boundaries are permanent, stable, and as in land borders, we cannot just keep changing depending on who comes to the power. In Morsi period in Egypt, we know some agreements, some controversial agreements were repealed immediately after he lost the power in Egypt. So, I was gonna say something else, sorry. What I'm saying is, in international relations, states are the highest actors. There is no authority above states. States are, and there's another principle we call sovereign equality. So every state is equal, regardless of their size or military power or whatever. In that sense, every state has a right to recognize whichever state they would like to. And United Nations cannot recognize Libya government as a legitimate government on behalf of other governments. So this is a reciprocal procedure. So any government, so we know that Russia doesn't recognize Kosovo, right? And we know that United States does not recognize Abkhazia. So this will stay as is. For Russia, Kosovo is not an independent country. So for United States, same. And Crimea, is it part of Russia or not? So if an American citizen goes to Crimea, they will have to give their passport to a Russian authority. So what I'm saying is, in international relations, you can recognize whoever you would like, even though all other states are not recognizing that country. So in that sense, those agreements in their specific, mutual bilateral relationship, it is valid. But the problem is you cannot enforce it to third countries. So there is a principle under Vienna Treaty Agreement, Article 34. You cannot sign an agreement or enter into an agreement to the detriment of other states, third parties, which are not part of the agreement. So Turkey-Libya agreement cannot take Greek maritime areas and share between two countries. Or it is a valid principle when it comes to delimitation. Unilaterally, you cannot delimit your own maritime area. You have to negotiate or go to court. There are ways to resolve the dispute. And sorry, it took it longer than I thought, but maybe one sentence. I will let natural resources. So we see a tendency in international court decisions that anything other than geography, this includes fishing, natural resources, even geological formation of the seabed, security concerns, historical claims. So these factors are generally not taken into account. Courts say, if I make a boundary line based on the hydrocarbon resources, petrol resources or whatever, fishing. So once these resources are not there anymore or they lose their value, are we gonna come back together and change the boundary again? No. So that's why we're not gonna make any boundary line based on the non-geographical factors. That's the general tendency of the court. So at the end of the day, if there is a maritime boundary delimitation in Eastern Mediterranean by a court, we won't see those factors being effective factor in delimitation.
Thank you, Emre. I would like now to ask Nicholas on his view concerning the situation with Northern Cyprus, and of course this is preventing the delimitation of the border with Turkey, but what is his view on the prospects of the solution for this dispute? Is there any possibility of course, still abiding to the decision not to recognize this entity from the government of Cyprus, but to reach a solution which would be workable also concerning the delimitation with Turkey?
Well, yes. Regarding the continental shelf delimitation agreement between Turkey and the so-called Caspian Sea, it is noteworthy to mention that Turkey was not allowed to register the agreement with the UN because exactly the Caspian Sea is not a legitimate entity. It has no international legal personality. And apart from the two Security Council resolutions pronouncing on the illegality, on the invalidity of the TRNC, the court in the Kosovo advisory opinion also made a distinction between the Kosovo case and the TRNC. The court specifically mentioned that the TRNC can never become, it was installed in the act. As I said, there was a violation of the Jus Cogens rule, so it cannot be recognized, it cannot attain international legal personality. Of course, the particular agreement reflects the long-standing Turkish facing along a coastline should take a lesser maritime space. That's why Turkey has gained a broader space than northern Cyprus in this respect. I believe that the particular problem should be resolved in the broader context of discussed this. As well, where, as I said, security and defense was taken into account, hydrocarbons, even though not explicitly, but it seems that the judges took that into consideration in deciding how to draw a boundary, and that we can see that if we read behind the lines in several cases. Thank you.
Thank you, Nicholas. I suggest now, because the time is closing out very quickly, that we open the floor a little bit to the audience if someone wants to ask a question to any one of you. And if there are no questions, maybe you can then interact with each other a bit and maybe ask for clarification what has someone said. So is there maybe a question from the audience? I had a question here from one of my colleagues who said that his connection is not good, but it's not really directly related to the topic. Actually, he wanted to ask Nicholas about some kind of parallel on the control of cultural heritage between the Turkish part of Cyprus and the Republic of Cyprus as in parallel to Kosovo. But I think I will skip that question because we don't have time for it, and I can email it to you. So is there maybe some question concerning this topic directly from anyone from the audience? Duško, please. Duško Dimitrijević, our colleague from the Institute.
Dear colleagues, I would like to take this opportunity to greet all the participants of today's gathering. I wish to make a question to Mr. Emre. We heard that the Turkey rejects the solution codified in UN Third Convention of the Law of the Sea, and we know this approach is based on the theory of contiguity, geographical proximity, and geological prolongation. When you put this theory in the context of political doctrine of the Turkeys, of the blue homeland, Mavi Vatan, do you explain the new Turkish doctrine, which among the other things projects the expansion of Turkish sovereignty in the Mediterranean, Black Red Sea and agencies too, with military bases in Qatar, Somalia, as well as on the Sudanese island of Sunikin, whose size, according to the publicly published data, should occupy an area equal to the half of the Turkish mass. Are the naval military exercises conducted in 2019 in the Black and Aegean Sea and the Eastern Mediterranean in fact a demonstration of this doctrine? And is Turkey most likely excluded from the regional maritime agreements such as the Eastern Mediterranean Gas Forum because of this approach to the resolving open issues with neighboring countries? What is your opinion? Is it possible for the crisis in Eastern Mediterranean to de-escalate it through the mediation of USA, EU, and NATO? Fact, please.
Thank you very much. It's an amazing question. Some of the answers would go beyond my expertise. I do have personal opinions. I'm not sure if I want to, make deep comments on the areas that not within my expertise. So I will try to answer those questions, but based on maritime law and how that doctrine that you mentioned is become part of Turkish. So I call it so that the audience will have a better idea what we're talking about. Just give me 1 second. Lots of map on the screen. So here is, let me share the screen. Just give me 1 second. Okay. So here we see Mavi Vatan Doctrine, Blue Homeland. This is the map you were talking about, I guess, right? And this map shows Turkey's maritime areas around the Turkish mainland. So based on mostly equidistance line between the mainlands, not considering islands, ignoring the islands easy. So this is a new theory which came to our attention in 2019, which was not here. So Akis was part of these negotiations before. Akis, you haven't seen this map before 2019, I guess, right? That's what I assume, yeah. So this is a new map. So I have another map where Turkey registered with the UN, claiming its exclusive economic zone. It's not a very clear map, but you see, this is what Turkey in 2013 has given to United Nations, saying that this area belongs to me, and anything beyond that line, we can talk and negotiate about the maritime boundary delimitation. So we see a very dramatic change in Turkish position, maybe part of that doctrine that you mentioned, which is reflected in maritime boundary delimitation. So I call, as I said, neo-nationalist perspective claims more than what you can claim. So just related to this, I'm going to show two maps next to each other. So this map is being distributed within Turkey every day. So basically, this map shows how much area Greece has and how much maritime area Turkey has. The Turkish line here. And when Turkish people sees this map and this map together, they say, okay, Greece lost its mind, you know, basically claiming everything, but giving Turkey just a little bit of maritime area. What we see here makes sense. That's the feeling, that's the sentiment. And this is very similar to what Chinese officials often exchange with their own public. So these are two maps. So this is one map, which is according to international law, you know, these Korea, Japan, and their islands have full effect, you know, full-fledged, whatever we see. And this is how much maritime area China should supposed to get. And China shares this map with its own public, saying that, like, we have a huge land mass, and this is what we're supposed to get. So when you look at this map, there's an illusion here. Depends on the perspective. You can say, wow, China is right. I mean, you can't give Japan this much land, and then just squeezing China's maritime areas into a small corridor. So, but the fact is this. The fact is, China is going 2,000 kilometers from its doorstep, claiming all these area. which is completely against international law, which is not acceptable. Same for Turkish situation. So what we see here in Turkey's situation, the relevant area of the maritime area should be only this area. We shouldn't talk anything beyond the coastline. We shouldn't talk about Ionian Sea. It's irrelevant. So this is the fact. Greece is this. Greece is not just about mainland. It's not just about here. So basically we see the Aegean Sea and part of Mediterranean Sea is dominated by Greek islands. One last comment before I go. This is the map Çavuşoğlu, the foreign minister of Turkey, is holding in his hand. So the trick here is the map shows Ionian Sea, which has nothing to do with Turkish claim, but not showing Black Sea, which is also irrelevant. So basically trying to show as many maritime area belonging to Greece and less area belonging to Turkey. So when we talk about this type of claims, we should always consider what is relevant area, what we are really talking about. So let's go back to your question, and I'll try to wrap in like 1-2 minutes. So I agree. Turkey's recent maritime claims are not aligned with its previous established long-standing position, and this reflects a new ultranationalist policy. And I see more military involved in this process. Like the mastermind of this Blue Vatan doctrine are two retired admirals, and 10 military people, both on Greek side, maybe Akis will agree, on Turkey side, they tend to have more like nationalist views. That's why I always say we should first let the civilians to discuss and try to negotiate. And whenever someone makes any comment in Turkey against Blue Homeland, which I am strongly against, which I believe it is weakening Turkey's rightful position, and which is overshadowing Turkey's long coastline, which is a strong argument, and it is only isolating Turkey, isolating from Middle East Gas Forum, isolating from Middle East EastMed pipeline project. So why Turkey is isolated? Why Turkey is not part of the regional prosperity? Because of these aggressive and maximalist and excessive claims. That's what, and they become part of the foreign policy. So Nicholas, I will ask you to show in a second Greece Egypt map, if you don't mind. So what I'm going to show is, as a state, you can have some claims. Academic people can discuss on excessive claims, but as a state, you cannot make an agreement blatantly taking some Greek land, say maritime area, and claiming jurisdiction over those areas, which is Libya-Turkey maritime agreement. It can be part of a think tank report. It can be part of an academic discussion. It can be part of an article, right? But what I see here is Turkey's long-standing position, 28 longitude. This is what Turkey registered. And what I see in the map that Nicholas is going to show us. Nicholas, do you mind showing the map for a second? So you see this line. Just look carefully on this line. Oh, sorry, I need to stop sharing the screen. Please go ahead. So here, the point A, if you can show on the map, Nicholas, point A, on Turkey, Greece and Egypt line. Yeah, point A, it is 28 longitude. So what Greece is doing basically, I am making a boundary line, but I'm not taking it beyond 28 because I know it's a dispute with your long-standing position. So this part, I'm not going to take unilaterally an aggressive position and just make a line all the way to Cyprus, because I know you have claims over here, and I'm not going to go beyond that. So this should be the official position. If you don't care about what other states are, claiming, that's not only against international law, but also against good faith and peaceful resolution of disputes or good neighborhood relationships, etc. So I took it long, but I tried to make it specific to this maritime dispute. But what you say in this context makes sense.
Thank you very much.
My pleasure.
Thank you, Emre. So would anyone else from the panelists like to comment also on this question or on Emre's comment? Because we are now really running out of time, and Nicholas, Akis, maybe, or no? I mean, then anyone else maybe has some question from the audience, or should we start to wrap up a little bit? Okay, I would like really to thank you, all of you, for participating in this panel. It was a pleasure really to listen, because simply the expertise that you offered us will really help with the research from all the members of the Institute of International Politics and Economics who are actually researching in international law, and also to wider academic community in Serbia. I think we had an interesting discussion, and this is visible from the fact that Akis canceled his meeting, which was supposed to start at 6 o'clock, so he stayed with us half an hour more. If no one else from you would like to add something, I would call it a day, and see you in some other sessions, and we will keep you informed about all our events, and maybe even ask you sometimes to provide a paper on these topics for some of our research journals, but we'll talk about that. Thank you very much, and goodbye. See you.
Thank you. If I may, thank you very much,
Yes.
Mihajlo, and thanks to everybody for listening. It's a very technical issue, and I think we did try not to go to too much details, but it's a great opportunity to talk to you all, and I hope the next time will be in Belgrade with a good time slot, right? Okay.
Sure. I would be really glad to host all of you in Belgrade for a live session on this same topic, maybe next year, if the epidemic allows it.
Yes. Fingers crossed. Thank you again.
I'm ending the meeting now. Goodbye.